right, good afternoon, and thank you for joining us this week. We've got a big week coming up, three events this week, today, tomorrow, and Thursday, and what's being called Armageddon Week at the Federalist Society. It's actually in honor of the Constitution. Constitution was actually signed on the 17th of September, and I know what you're thinking, that was actually last Friday, but as it turns out, no one comes to class on Friday, so we're just going to go ahead and call that the start of the week, and so this week is our Constitution Week. Today, we have a debate format for you, and the topic is Obamacare and the law. Are individual health care mandates constitutional? Our two speakers are Mr. Robert Alt from the Heritage Foundation and Professor Mark Brown, who was a professor here at Ohio State, is now a professor at Capitol Law School. I'll give you a short introduction of each. Before I do, I'd like to give just a quick format update. We're sticking to our 12-minute introductions and then the 10-minute rebuttal followed by questions from the audience. And we'll begin with our guest speaker, which today will be Mr. Alt. Robert Alt is a fellow in Legal and International Affairs at the John Ashbrook Center for Public Affairs at Ashland University. He's also, of course, the senior legal fellow and deputy director for the Legal and Judicial Studies at the Heritage Foundation. He has written and lectured extensively on issues of constitutional law, with particular emphasis on civil rights, election law, separation of powers, and anti-terrorism. Mr. Alt teaches legislation at Case Western University Law School. He's also a Buckeye native. He's written extensively with his first-hand experience in Iraq. He went there in 2004, during which he observed and wrote about the shift in transitional government. Mr. Alt has testified before the FEC and has published articles in the Wall Street Journal, Washington Times, Daily Standard, San Diego Union Tribune, and he's a contributor to the National Review Online. He earned his his JD at the University of Chicago Law School, and he clerked for the Honorable Alice Batchelder at the United States Court of Appeals for the Sixth Circuit. Mark Brown is a constitutional law expert. Professor Brown is Capitol's Newton D. Baker and Hostetler Chair of Law. He joined the Capitol faculty in 2003. As I mentioned before, he was a professor here at Ohio State. He's also been a professor, faculty member at Stetson University, Florida State, and the University of Illinois. He's co-authored a book called Constitutional Litigation under Section 1983, and he's authored several articles addressing various constitutional issues, including religion, elections, parents' rights, gender discrimination, and the government's financial liability for the wrongs that it inflicts. He was the valedictorian of his law school at the University of Louisville, and he went on to earn an LLM at the University of Illinois. For 18 years, he was a cooperating attorney with the ACLU of Florida and has litigated many pro bono cases with them. He's clerked for the Honorable Harry Welford for the United States Court of Appeals for the Sixth Circuit and was a judicial fellow at the United States Supreme Court. So we'll begin with Robert Alt, and please join me in welcoming him.
Thank you, and thank you to Mr. Schirmer for making this event possible today. The passage of the healthcare reform litigation was surely historic. Anyone who questions that need only look to the august words of Senator Biden upon its passing that this was effing huge. But it's just as surely unconstitutional. Notwithstanding that, those who passed it made bold statements as to their authority to do so. When Speaker Pelosi was asked whether or not, by a reporter, where specifically does the Constitution grant Congress the authority to enact an individual health insurance mandate, Pelosi responded, "Are you serious?" Similarly, when Congressman Stark was asked a question about what sort of limits are there, based upon the passage of this bill, on the ability of the government to intrude into individual judgments, he responded, I think that there are very few constitutional limits that would prevent the federal government from rules that could affect your private life. When he was asked a follow-up question, based upon such antiquated notions as enumerated powers, he responded that the federal government, yes, can do almost anything, most anything in this country. Given the modest success to date of the litigation challenging the healthcare mandate, surviving motions to dismiss, which would be, sort of for the non-lawyer, the "Are you serious?" test, I suppose the answer must be yes to Pelosi. Those challenging the law are serious. I'm going to address what I think are two major problems with the bill today with regard to the individual mandate. One, the enumerated powers question with regard to the Commerce Clause, and two, the tax or penalty issue associated with it. Under the individual mandate, all Americans subject to a hodgepodge of excluded individuals must either purchase health insurance or pay what the bill calls a penalty, but which I believe that what lawyers in the IRS will recognize to be a tax. Both the requirement to purchase and the tax violate the Constitution. The requirement to purchase is made under the Commerce Clause. Those familiar with congressional legislating will be unsurprised to see, if you look at the text of the bill, the relatively perfunctory language employed. Congress found that health care substantially affects interstate commerce based in large measure on aggregated annual health care spending. And with that, those who have some hope of challenging the law in this room inevitably begin to become despondent. After all, you have flashbacks to con law class. You recall, wasn't there something about wheat, Farmer Filburn? And doesn't that really sort of answer the question? If the government can regulate the crops that Farmer Filburn raises for personal consumption, those that aren't even going to be sold in the open market, and the government can restrict the wholly intrastate possession and distribution of marijuana, both based on aggregation principles, a la the Raich case, what's left? What is left are classes of activity that are non-commercial in nature. In both the cases of Wickard versus Filburn and Gonzalez versus Raich, there were no claims that Congress did not have the authority to regulate the larger classes of activity, i.e. the aggregated interstate commerce in wheat, and what I believe the Californians referred to as the intrastate possession of chronic. In both of those cases, the sale or the production of a commodity, either an open market or a black market commodity, are necessarily economic activities which Congress can regulate. The Supreme Court in these cases, the key in looking at these particular cases is that those who were attempting to challenge them did so on an as-applied basis. And the Supreme Court in these and other cases has shown the back of the hand to as-applied challenges with regard to the Commerce Clause. If Congress has the authority to regulate the larger class of activity, then individual incidences of intrastate activity swept up in the regulation that might not otherwise be permissibly covered, nonetheless will be permitted. Thus, the test is whether Congress has the authority to regulate the larger class of activity, not the individual instances. And once one refocuses in this way, the landscape becomes a little clearer and the reason for despair becomes a bit less. With regard to Lopez, the Gun-Free School Zones Act, again, in this particular case, the possession of a firearm is not in a school zone, is not in and of itself an economic activity. And despite the fact that they make the same sorts of arguments there that they do here, which is to say that there are downstream externalities which in fact have economic effects, the court wasn't going to buy it. You could not regulate a non-economic activity to reach, something multiple steps down the chain of causation. That ends up being key in this case because if you take a look, quite frankly, the core of their argument, and we'll look, they've actually changed what quasi-economic activity they're claiming they're regulating at least 3 times in the course of their defense of the health care bill, that is the DOJ. But probably among the best arguments they have is that somewhere down the chain of causation, there is an economic activity that's being regulated. Lopez actually creates a serious problem for that argument insofar as if the actual activity you're regulating is non-economic, they're not going to allow you to go to use the butterfly flapping its wings in Malaysia affects the economic market here, and therefore we can regulate butterflies argument. Morrison gave us, in many ways, more of the same, and reinforce the idea that simply because Congress makes cursory findings, those aren't going to necessarily be dispositive. So insofar as they simply, sort of made a blanket finding as to the economic effect with regard to the healthcare market, that doesn't really tell us anything about the mandate as opposed to those who have engaged in the inactivity of failure to purchase. And that's where I want to step back to for a moment. Here you have individuals who are seeking not to enter into the marketplace. Congress would literally be regulating not activity, but inactivity, rather than a class of activity. The only way for Congress to claim that it's regulating activity is to point to the amount spent on health care, but as in Lopez, this is too attenuated. It is not within the class, but stands outside of the class of inactivity. And in this way, the individual mandate is literally unprecedented. There is no precedent for an individual mandate to enter into a contract with or to buy a particular product from a private party with tax penalties to enforce it. Indeed, the DOJ seems to have quite a bit of problem deciding what it is that they are regulating. They have waffled between saying they are regulating the insurance market generally, which is problematic, as we've already discussed, because those they are regulating are not in that market. Then they suggested that they are regulating market timing, those who wait to purchase insurance. But they provide no evidence that this is what is occurring, and they provide no reason that they do not regulate at the point of service, rather than several steps prior to the point of service. Finally, they have said that they are regulating the act of self-insurance. I think this is the most clever of their arguments, but again, it's not necessarily, there's no congressional findings to this effect. There's no evidence that this is in fact what's occurring. In fact, some people are probably self-insuring. Some people, you can easily come up with a hypothetical, including my friend's grandmother who refuses to go to doctors at all under any circumstances. They may be seeking not to enter into anything related to the medical insurance or medical care market at all. But let me take a step back and respond to sort of a non sequitur argument that comes up frequently, which is, well, what about auto insurance? You say that there's no precedent for a mandate of this sort, but we all have to purchase auto insurance. Most of the states have some sort of a requirement that you purchase auto insurance and mandate that you do so. That would be different for at least 4 reasons. The first, I've already alluded to in saying most of the states have that requirement. It's a state rather than a federal requirement, and that, of course, is most of the game. The states have plenary police powers. Contrary to what Ms. Pelosi seems to believe, the federal government does not. And the fact that they're in court right now and they've lost on motions to dismiss goes to the fact that they do not have such plenary authority. Second of all, it's actually a condition of driving and not of being. This particular mandate provision is not based upon your exercising of a particular privilege. It's based upon your exercising breath. And that makes it, I think, just policy-wise, a much broader assertion. It's also a condition of driving on state roads, not private property. And thus, if, for instance, you own a car and you're out in some large square state in the West where there's large open plots of property that are not owned by the government, you don't have to have insurance or even a driver's license, for that matter. And finally, interestingly enough, it's actually much more of a tort protection provision than it is a nannyish protection of the individual. It's in terms of that. So thus, to make the case perfectly blunt, if I get in my car and I decide to drive into a telephone pole, I need to have auto insurance not to protect my vehicle or myself, but to protect the telephone pole or other drivers on the road. No state actually requires you to have insurance to cover your own vehicle, although you may have to, through contract with your lender, have that, but that's just them forcing it on you through private contract to protect their underlying investment. Now, if you don't purchase the mandated insurance, the provision provides for a penalty, or what really operates as a tax.